The October 2023 Visa Bulletin was not what we expected. Unfortunately, then cases did not move up well, but we're here to describe ways that you potentially benefit and beat the Visa Bulletin with my wonderful associate attorney, Anya Sergeyev. We're going to go over the family-based cases and employment-based cases, things you need to know and potentially could help you speed up your immigration and green card process. Thank you, Anna, for coming in. What's the first thing you want to talk about?
Well, first thing, F2A category. This is probably the most common issue we see. F2A category covers the spouses and children until they turn 21 years of age. Okay, so if you're a green card holder and you're filing for your family overseas, let's say, okay, one thing that you can do potentially is that you can naturalize if you're the petitioner, okay, because once you naturalize, the Visa Bulletin does not matter.
This is so important that you brought up category if someone becomes a citizen. We have this a lot because it speeds up the process, but on the downside, if you have children on that case, the children drop off. Can you describe more about that?
Yes. So first thing, as we mentioned, naturalizing, please make sure if you are naturalizing, you talk with an attorney because they have to make sure that you got your green card lawfully and there are no errors. Okay. Because naturalizing not always work for everyone. Okay.
Speaking of the Visa Bulletin, we've had cases where people come where their green card was approved when it was not current. And then when they go to get citizenship, the officer says, oh, you shouldn't have got your green card. And at that point, 5 years have gone by, and they're like, well, we're going to take your green card away. So it's a horrible nightmare. And that's why you want to check to make sure all the processes happen correctly up until the time you get your green card.
So going back to what we were talking about, F2A category spouses and children before 21 years of age. So first thing, again, naturalizing, but please be careful with that. Okay, and for example, if you filed only one petition for your spouse and children, this category allows derivative beneficiaries, but once you naturalize, the kids will be out of this petition. Okay, so you have to be very careful with that if you consider naturalizing, because again, if you naturalize, Visa Bulletin will not matter for you any longer. You'll retain the same priority date, right? But again, please talk with the attorney. One more thing is that naturalizing can affect CISPA Child Status Protection Act calculation. This is very complicated topic, and it has to be assessed precisely in every single case.
Yeah, the children could lose the protections of it if you naturalize. So it's a very tricky situation. And we've had people who thought they're going to naturalize and fix it, end up dropping off their kids and losing their priority dates. The kids have to be reapplied for, but then they become the longer category. It's a huge nightmare, so something to be mindful of. So F2B petitioner can naturalize, just something to be mindful of that. Now, Anya, the next thing I want to talk about is F2B category. Sounds like the F2A being, spouse and minor children of green card holders. F2B is adult children of green card holders that are unmarried. So it's very important to be aware of that because if you have a case like this pending, and this could take 8 years or longer, and the child gets married, it destroys this category. So you got to make sure they don't get married unless the petitioner, the parent, becomes a citizen. Then if the child gets married, they can still keep the process going. It's going to take much longer, but that's possible. Now, historically, for the last 10 years, the F2B adult child of a green card holder line was going faster than the F1 adult children of a citizen. And so many people did not naturalize because they're afraid they're going to take longer. Now, there is a rule in the regulation that say if you're F2B and you automatically go to F1 because the petitioner, the parent, becomes a citizen, you could keep your place in F2B. So normally we would do that and opt out of the transfer to the new category. Right now, as of October 22, things are readjusting the Visa Bulletin, and the F1 adult child of a U.S. citizen is going slightly faster than adult child of a green card holder. So I know there's a lot of F2B, F2A, F1. It's very confusing, and hopefully I haven't messed it up too much for you guys, but just be mindful of this, see which one works best, and go accordingly. Check every month, and if you see your case's priority date is getting closer, adjust yourself accordingly and make the changes you need. Talk with the immigration attorney to either opt out of becoming F1 or push it and say, hey, we're F1 now. Let us get our interview. Let's move forward. Every month these things change, so you got to keep an active eye on these things.
Right. And if we're talking about like other family-based categories, important to know, for example, if your category is F3, F3 is married children of US citizens, right? And if you get divorced, right, you can switch to the F1 category, which has so much better Visa Bulletin timelines. But again, very important to note is that the divorce cannot be like fake just for the immigration purposes, and you cannot just divorce and then remarry. Okay, but if something happens, okay, you got divorced, don't forget to notify USCIS or NVC, National Visa Center, depending on where your case is at, so that they will move your petition to the proper category, and thus saving you a lot of time, potentially a lot of time, like years of time.
Definitely. So the timelines are huge. And so the next category, especially I'm going to talk about, which is brothers and sisters, siblings of U.S. citizens, are the longest. And so we got to prepare for these things. You know, ideally, you file for your brother and sister. This is going to work out. Eventually, time comes where they get their green card. But time is a lot. So some people just give up on this. What's really important to note is a lot of times the sibling green card is for your nieces and nephews. Your brother and sister have children. They're minors. Gives them the opportunity to get a green card in the future. So in this category, if you tell your brother and sister it's going to take 15, 20 years, they're going to lose hope, but just don't lose hope, because it's a lot of times this is for nieces and nephews for them to get here. And who knows, time flies, and maybe 15 years passes and they still want to come to the United States, or there'll be new regulations that pop up that say, if you had a brother or sister case, you get points in this new immigration system we have. In recent updates that they were trying to do for upgrading and updating the immigration system, they had made mention where if you had a sibling case, we're going to stop doing those. But if you had one pending, we're going to give you plus and positive points towards a new program. So that's why having this in motion is not a bad idea to do it. And in the meantime, especially if you have an immigration attorney helping you, you could talk with them about other options, for example, employment-based options, investor options, other things that could pop up that could help take that case forward. So don't write it off completely because of how long it takes, but be mindful of the benefits and other advantages that the family-based categories have. So that's it for family-based, but we're going to go to employment-based right now, which is really important. These are the people who are studying this chart because it really hurts their life. They're stuck sometimes in jobs they may not want to be for extended periods of time. Anya, can you talk a little about the EB category and the things we see are problematic and how we help people?
Yeah, like first thing I wanted to talk to you about today is like when employment-based green card holder filing for family member overseas, we talk about all the time, I-824 and stuff like that. So we usually suggest in this kind of situation for our clients to file both I-130 and I-824. And specifically, this would make much more sense right now with the October Visa Bulletin, because if you file I-824, you retain the primary applicant's priority date. But when you file new I-130 under the F2A category, spouses and children of green card holder, you'll get a new priority date. This Visa Bulletin, that's how you can like overcome this.
Now, if you look online, the most amount of videos on the subject is you. So you are the queen of the I-824. We get at least 5 to 10 emails a day on this subject, unfortunately. So just to back up, it's where people do employment-based green cards. They get it in the United States, but their spouse and their children were overseas. So you're a guy in the U.S. on H-1B, you get the green card, but your wife and daughter were in India, and then now they can't come back. And so then you have to do an I-824 to get them to come, and the I-824 takes forever. It's a horrible form. Typically, we would just do a new I-130 as well, do both and see which one happens first. But the timeline for I-130s for spousal green card holders, that F2A category we talked about, got really pushed back. And that might change. So the option is do both and pray which one happens first. But I-824 allows you to hold on to the, as you said, the priority date. And if you have a child, they could lock in their age for Child Status Protection Act. If they're 19, 20, 21, there's a fear of aging out. So some really important stuff to be mindful for that.
Right. And John, can you tell us about like other like EB potential candidates under the employment-based immigration?
Yeah, so the EB is a wonderful category. There's so many subcategories. It's kind of confusing because you say an EB1, but there's 3 subcategories of extraordinary ability, researchers, and multinational managers. Each of those are wildly different. So, but typically EB1 is the fastest. Usually everything is current except India and China, but it usually works the fastest. So if you can, try to tilt your case towards an EB1 kind of case. EB2 NIW is possible too. This is the national interest waiver. It falls within the general EB2, which is the backlog. It has different standards in the EB1, but somewhat similar, so something to look at. But EB2 is better than EB3. But be mindful that these timelines are wild. They don't make any sense. So 2 years ago, we had a situation where EB3 got faster than EB2. So a lot of people did what's called a downgrade. They took their EB2 and made it to EB3, and then the EB2 went faster, and they had to do an upgrade, and it caused a lot of havoc in immigration. A lot of people got their green cards approved incorrectly because of that, and we don't know what's going to happen with that. It's almost as if when you're driving down the highway and the lane you're in slows down, you switch lanes, and then the lane you're in goes faster, you want to go back to that lane. It's a mess, but these things are there, so be mindful of that. And also be mindful of priority recapturing, which is, let's say you started in I-140 and then it was approved, but you never went through with it. 10 years later, you find a new company that wants to hire you. Potentially, you could keep that old priority date, which could really help out, especially if you're from India and have the huge backlog kind of issue. There's a lot we can talk about that. Let's keep it at that. But Anya, two really important things to talk about, which is MVC terminations and mistakes people make on the application. These are pretty much like the two top issues that we see that people on their own need to be careful of so it doesn't happen.
Right. So very important considerations. If we're talking about like Visa Bulletin and speeding up your case, right? A lot of times, once your case makes to the National Visa Center and time goes by, and you don't do anything with your case, NVC can terminate your case, meaning that they just destroy the petition. Sometimes it's possible to retrieve it. Sometimes it's not possible to retrieve it. The general rule is that once your case is at the National Visa Center, you have to contact them every year. Make sure you do a screenshot, or like if you do like public inquiry, they're going to send you automatic email. So make sure to save these records for future years if something happens. Okay, so don't let NVC to terminate your case, because again, if they terminate your case, that's it. Your priority date is gone. Like you won't be able to.
A quick note on that. I had a woman contacting me. Her case went to the MVC, but it won't be current for another 6 years. But they gave her case ID number, everything to log in now. So it's really confusing. If that happens, you got to just make sure if you could, it's the right place. So essentially, if your case is current or getting current, you need to follow up, and the MVC will send you a termination email or notice. So if you get that, make sure to talk with them, say keep it open. But it's tricky when they, for some reason, give you the access codes way early when they don't need to, and that creates a little bit of confusion. What's the other thing that's just pretty much the most important of all of it? Seems very simple, but this is the most important thing.
Yeah, we talk about this a lot, but trying to avoid mistakes when you prepare and file your case, because again, sometimes when we have clients, they come to us, we can fix these mistakes, for example, by doing a new filing, right? And the new filing comes with the new priority date, so you lose on time. Sometimes we can do it without new filing, so it's really very, very case specific, but of course it's better just not do any mistakes. If you're preparing the petitions yourself, please make sure that you read the instructions carefully. Okay, make sure you put the right information, you follow everything that is in the instructions. So this is very, very important and part of the beating the Visa Bulletin process, so that you don't have to refile your case and get a new priority date and get again to the back of the line.
For sure. I mean, we've had cases where a green card holder filed for their spouse and they're supposed to do visa processing at the embassy, but they mistakenly listed they're going to do adjustment of status in the U.S. And once that I-130 was approved, they had to file this I-24 form, which we talked about, which takes over a year most of the time to approve. So by the time the I-24 was approved and the case was sent to the National Visa Center, the priority date system, Visa Bulletin, went backlog for F2A. And now, instead of getting case done, they got to wait 6 years potentially. So huge nightmares could happen from not doing clean work. That's the most important thing. If you want your case handled well and with attention, feel free to contact us so we can get started. Our email is info@jqqlaw.com, or probably best to email Anya directly. She's a big boss of the company, Anya@jqqlaw.com, ANNA@jqqlaw.com. Thank you so much, Anya, for coming on the show again. And I'm sure we helped some people speed up their lives and get to their goals much faster with this video.
Please feel free to reach out if you have any questions left unanswered. We will be really happy to help you.